Now we'll start.
Yes.
Good morning, one and all. I welcome all of you on this day 2 of our PROACT PuneCon 2022. To begin with our first session of the day, every anesthetist should be aware of the medical legal aspects of anesthesia practice, as it is very important for modern medicine. So to elaborate on the same, we have our first session of the day on medical legal update. I kindly call upon the stage Dr. Pratibha Kane and hand over the proceedings for the first session.
Good morning, everybody. Today we are doing a hybrid session, and it is my pleasure to welcome for this session our chairperson. How does it go forward?
Pointer nahi hai aaj.
He's not there. नहीं ना जाते हैं थोड़े.
Sujit sir, clicker nahi hai.
Click.
Next slide.
नहीं ह्याच्यात नहीं ना, next slide नहीं होता है.
एक मिनिट आता मी जस्ट चेक केलं तुमची स्लाइड सुरू करून गेली.
काय करायचं सांग मला.
Just the arrow keys.
हे का? All right, so we have our chairperson, Dr. Kalpana Kerkar, who is professor and HOD of Department of Critical Care Medicine in D.Y. Patil, Pimpri. She has many major achievements. I'm not going to spend any more time on this, but she, I think, has the recipient of the best research papers and the recipient of Lifetime Achievement Award for Anesthesiology and recipient of the Hall of Fame Award for Poetry and Devotional Music, and many publications to her credit. We also have our chairpersons. Next is our Dr. Kohn, who has trained in VJ Medical College. Today, she is presently teaching at Noble Hospitals, Pune, and she has 47 years of experience behind her. And she was instrumental in those days in organizing workshops for surgeons, and her major projects have been tracheal reconstruction surgeries, and she worked as a chief anesthesiologist for operative workshops of head and neck surgeries. Our speakers who are joining us are experts. We have Dr. Sadhna Kulkarni, who is speaking to us from Aurangabad, and she is professor and HOD of emergency medicine and in charge of skill development unit in MJM. She also has a tremendous amount of awards, national and state awards for public awareness about anesthesiology, and Lifetime Achievement Award of PRAC. More than 80 publications to her credit, and her winsome smile is, I think, the best. We have with us Dr. Naurange, who is an accomplished pediatrician, but he is really our go-to person for any medico-legal problems in Pune. He's the Iron Man behind a very active medico-legal cell of IMA in Pune. With this very short introduction, we're going to start our session, and on three very important topics. Basically, not to elaborate too much on the topic, but just to create an awareness that these are problem areas, and one has to deal with them in their area of influence. So, sorry. Oh, I'm so sorry. No, I thought I'm really sorry, sir. Dr. Meenakshi Sundaram, I can say he needs no introduction, but no, he's got the best teacher award and the best doctor award, and he is a Tamil poet, which is really so amazing. and he has tremendous knowledge and an extreme, Dr. Bhatia is saying, extremely great sense of humor. And yes, I will give him credit for that too. I'm so sorry, Dr. Sundaram. I think I just wanted to get on with the subject. All right, so he is actually leading with us on the first topic. And that first topic is pre-anesthesia consultation with a physician. So the question is a physician fitness a legal requirement? And how does it add value to the anesthesiologist? Dr. Sundaram, sir.
Thank you very much, madam. First of all, I thank the ProAct Pune team for having given this wonderful opportunity to me. Now, first of all, I want to make it clear that I am going to talk as a legal person. Please don't consider me as an anesthesiologist and don't argue with me in medical science. It is totally different. That is, every time I am facing that problem, I am not an anesthesiologist. Please forget about it. Now, this question needs some elaborate answering. Is physician fitness a legal requirement? First, straight answer, it is no. Because the National Consumer Disputes Forum has given that verdict that anesthesiologist is responsible for pre-anesthetic fitness. So fitness is not a legal requirement. Then the anesthesiologist, they may argue and they will ask me as an anesthesiologist, if we are having a problem, what we will do. By coping in so many interdepartmental consultations, I feel personally, we have been dragged into a trap. I will quote only one example because I have only 2 minutes time to answer this question. See, the present case, very recent, in the August 2022, Shankar Nethralaya case, the case was filed in 2000. After 22 years, the judgment was delivered. You have to read that judgment because it is extensively discussed. A 6-year-old boy undergoing strabismus surgery was dead on the table. So the court has observed about pre-medication of atropine, how atropine acts, what is oculocardiac crisis. The judge says the atropine was not given in proper time. The halathane and scoline has produces bradycardia and hence there is cardiac arrest. So this much of a discussion is there in the case. But what I want to convey, the patient had a soft systolic murmur as per the physician's opinion. So the physician wanted cardiologist's opinion. The cardiologist auscultated the patient in so many ways and he said, no murmur, absolutely no investigation is necessary. So the anesthetist has taken up the case. But in the judgment, it has been mentioned, the cardiologist has not examined the case properly. As physician has marked that there is a soft systolic murmur, he should have exerted extra precautions, but the cardiologists have not done that. Fine. So far it is fine. The compensation ordered was 1 crore. Imagine the compensation ordered was 1 crore. In 1 crore, the court has opined 85 lakhs have to be paid by the Shankar Nethralaya hospital as vicarious liability and 10 lakhs by the anesthesiologist and 5 lakhs by the surgeon. Now where is the cardiologist? Now where is the cardiologist? The court, see, this is what happens. The court says the cardiologist could not be implicated in the case just because he was not mentioned as a respondent. The team, the patient team knows only the anesthesiologist and the surgeon. So if you are getting interdepartmental opinion, he may not be implicated in the case and it will invite a problem. Another example I will tell you, if there is a T wave inversion in anterior chest leads, it may be normal below 40 years if it is a female. But even if it is there, if you ask for an opinion, then they will say, they will not quote the ECG finding. They will say it is fit for anesthesia. There only the problem comes. So don't ask for unnecessary opinion. One, right? If you don't know about the diagnosis, you consult the specialist and inform him he is being consulted only for the diagnosis, not for the fitness. If T wave is inverted, he has to commit whether it is a coronary or not. That's where we have to stand. So it is not a legal requirement. And is it valuable to anesthesiologist? Absolutely no legally. Absolutely no legally. That is my straight question. Then if you want to have more opinion, you please discuss with him personally, but it should not be written in the case sheet that he is fit for anesthesia. Sometimes they are writing is fit for general anesthesia. He is fit for spinal anesthesia. These are the things should not be written. It is not a foolproof technique for the anesthesiologist. Thank you.
Dr. Kerkar wants to say something.
Hello. Hello.
Yes, madam.
So thank you very much for enlightening us that it is not a legal requirement. It is such a big solace because physician's witness actually even in my tenure I always can't hear.
Yes, hold on. Take the another one. Correct. Take the another one. Yeah.
Hello. Dr. Sundaram, can you hear me?
Yes, yes, I am listening, madam.
So I will start again. Well, thank you very much for enlightening us with this fact that it is not a legal requirement. Because so many times it so happens that actually I feel that anesthesiologist should be the perioperative physician giving fitness for anesthesia. And this word of fitness should actually be outdated. I mean, it should not be used anymore. We can just do risk stratification. And I always used to tell my students also that refer to physician only for proper diagnosis and optimization of the patient, which can be done medically. Otherwise, whatever perioperative medicine we know, we are definitely superior to the physician in giving the advice about this. And I was under the impression,
Madam, I don't want to say we are superior, we are better. Because it is a legal question. I want to say we are better.
Okay, that's my correction. We are better, but then that is a big solace, I think. Thank you, sir.
Okay, I beg to differ slightly on this. To me, I feel it is in today's day, it is a little dangerous to be perioperative physicians because we have very limited time to look at patients. And I feel that this is a time to spread responsibility because after the case is over, we have to hand over to some physician. And especially if they have comorbidities and, on medications. And we have seen just now, actually, I have not put up those cases, but cases going into court because they have not been BP of 140, 90, and they say that patient has not been treated by a physician. So what I want to round up and summarize this by saying is that there is no harm in getting, in fact, I feel that, we should get a physician involved, but the way we refer is not for fitness. The way we refer is, like Madam said, for optimization and the fact that there are perioperative risks. So if the medical person actually states that this person who has had a myocardial infarction before is having some risk of having a myocardial infarction in the perioperative period, a person who is asthmatic may have an asthmatic attack in the perioperative period or may need ICU, it really supports the anesthesiologist.
I agree with Dr. Pratibha, because the post-operative care, if we involve the physicians, the care is definitely better because surgeons alone, they cannot manage the medical conditions.
Here, the most important thing is when we refer to the physician, even if you say that he has to counsel the patient's relatives, actually the catch is, suppose a diabetic patient is taken for surgery, sudden cardiac death syndrome is a known entity in diabetes. If post-operatively something happens to the patient and the physician has given fitness on paper, the court can say if the patient was fit, why this complication?
That is why do not refer for fitness. Refer for just take that fitness word because anybody who is coming for a surgery cannot be fit to run a marathon.
Madam,
a fit person is
no patient is
Madam, Madam, that's what I said. You refer the case for diagnosis. But see, the problem is they are writing. Madam, they are writing. Then what you will do if it is written in the case?
So that's what
that
I'm
is the
saying.
reason
So
beforehand.
change the physician.
Beforehand,
No, we
Beforehand,
need to
Create awareness.
inform. Beforehand,
create
you inform
awareness.
the
Why
consultant.
I have brought this topic up is to create awareness that please do not refer for fitness. Whoever physicians you are involved with, ask them to write a detailed thing, at least mention the comorbidities involved, and they must counsel the patient, even mentioning about few perioperative risks that the diabetes may get worse or something. They must
Madam,
talk of some risk.
that is not possible, madam. Their training is entirely different. I beg to differ. Their training is entirely different, physician.
but we
Even I
need-
want to say, even in the post-operative period, I feel 24 hours, it is our moral responsibility to take care of the patient. Because the surgical causes of bradycardia, surgical causes of hypotension, that may not be examined by the physician because their training is like that. We are trying to do that. So it is not perioperative physician or not. Please understand, we have to take part in the post-operative care also because our brain helps the patient. I'm talking about the patient now, not about the legal requirement. Please, it is not just handing over once the moment anesthesia is over, then it will be like nurse anesthetist. We are anesthesiologists, we are saying. So I feel our knowledge is to be utilized. See, we are all learned people. We know how judiciously it could be operated. I'm not overstepping. Same way, I should not understep. That is my request.
Okay, so I leave this open. As far as I'm concerned, I like to hand over because it is really very difficult for everybody to keep following up, and anybody who is in any kind of risk about bradycardia, hypoglycemia should go to the ICU. I mean, we are at least in institutions, we tend to do that, that anybody we feel is in risk of any kind of thing, but we do hand over to the physician. We do not continue to give care. Okay, so this is our kind of what we follow over here. We do not, we really hand over a patient who has come properly out of anesthesia over to the physician to take over their insulin requirements, their cardiac drugs and everything else.
Madam, only one word, madam. We are not talking about your setup or my setup. Now it is a legal forum. That is the reason why clearly I said legally.
Legal responsibility.
Legally, even if you hand it over to the physician, legally you are responsible.
Yes.
Legally, I am talking about legally. Don't talk about scientific matters. Legally, we are responsible. That's the carry home message I want to convey. Whether you hand it over to anybody, legally you are responsible.
Thank you.
Okay.
Navranga wants to add something.
Yes, sir.
Yeah, madam, I listened to all these discussions, and these are age-old discussions. But what sir was referring to is a very unfortunate judgment, I would say, that the cardiologist is let alone. But otherwise, I would say that maximum number of opinions play the defensive medicine. The cardiologist should have gone for investigations if somebody has suspected some murmur and all that. And I think it must be the story of 2000. That is why they did not do any investigations. Otherwise, nobody tends to auscultate it to that extent, but go on with the 2D echo and all those. But anyway, sir, ultimately what I feel, there is one very good judgment. I don't remember the Supreme Court judgment's title. It says that you can, I think it is in this Amri case only, that you can involve maximum number of consultants, but there has to be a captain of the ship. So ultimate final decision rests on one person who is taking the lead. So really the decision, I mean, ultimately the responsibility will be on the anesthetist who is giving the anesthesia, but then involve as many number of doctors as possible and play the defensive medicine is the role today, which is not our teaching really, but then law has taught us now.
All right, so we're going to go on. So we leave this debate as is. As far as possible, I would say involve more people and hand over responsibility. But okay, there is a difference of opinion. Now we are going to the next topic. And the next topic is off-label use of drugs. And Dr. Sadhana Kulkarni is going to, kind of lead us with her knowledge and experience.
Thank you, Dr. Pratibha, for giving opportunity to talk on this gray area. And really, when I was preparing for this lecture, I learned many things. First of all, I want to clearly state that off-label use is not legally accepted in India. Now, when the drug comes in the market, it comes with the label and in which the various conditions are included where the drug can be used regarding the age, indication, contraindication, and dosage form, etc. But unfortunately, 20% of the perioperative anesthetic drugs are off-label. And in this condition, why anesthesiologist is forced to use that? Because he's facing different types of conditions, different types of severity of the diseases, and he has to use the combination of the drugs to maintain the cardiovascular stability or to prolong the analgesia. So that's why off-label use is common. Now, then are we exposed to more medico-legal liability in such conditions? Yes, because the policy is variable all over the world, and FDA, it permits the use of off-label use for prescription if it has come into peer-reviewed journals and it is scientifically proved. So also it allows the companies to promote that off-label use if it is based on the two peer-reviewed journals. And while in India, the thing is, if the DCGI doesn't give clear-cut guidelines. Legally, we are not allowed to prescribe any off-label drug. And second is, in India, the government says that you cannot apply FDA rules in India or guidelines because our people are not that educated, and because of that, and our prescription in India is affected by the pharmacy. So that's why we cannot apply those guidelines in India, and we are not allowed to use off-label drug uses. Now, in such conditions, what the anesthesiologist should do? When we are using, we must see that if it is a off-label use, is it given in the textbooks? So if it is given in the textbooks, legally the drug will be accepted. Second is document everything on the case paper, follow the patient and tell the patient that we do not know the side effects of this particular drug, so that the legal aspects can be minimized. And if you find any adverse drug, please publish it and also tell to your colleagues that these are the off-label use, so that the others won't use that particular drug. So, and for the institutes, I want to tell that if you are participating in phase 2 trials, please see that the DCGI approval is there. So also animal and human study report is there, and then only you try for that DCGI trial, and the insurance of the patient should be there when we are doing the phase 2 trials. So these are some of the precautions which we must take. Now, can we streamline this problem? So for this, what we can do is government, pharmacy companies, insurance companies, and the doctors, they can come together and discuss this problem. In 2004, I think IMA has represented to government for allowing FDA guidelines in India, and the decision was not taken, and yet it is pending. So it's more than 18 years, and definitely the people have now changed, because the COVID-19 has taught off-label drug use to everybody, and we have seen what are the side effects of those drugs. So unless we come together and create awareness, I think this problem cannot be solved.
And Dr. Kohn would just like to.
Hello. Hello, ma'am. Thank you so much for enlightening us on these aspects. Not aware of the legal implications of the off-label use. He said the Director Control General of India is the only one, but unfortunately cannot lay down practice exactly like FDA. But in India, it has been banned and illegally banned not to use, market, manufacture everything about the off-label use. And if you are liable to be punished in case the court or the police body confirms that the parent drug, whatever, has been tested and approved by FDA. Secondly, it was indicated for the requirements of the patient's off-label indication, and there have been enough trials. That is what is exactly what is required in the current scenario. Clear-cut guidelines for this. I would like to make a mention of the efforts put in by IMA, national body, in liberalizing the use, because major concern to the trials, FDA believes in trials. But we don't have the trials in pediatric age group. So are we depriving the children? Because just because there are not enough of trials. And unfortunately, ma'am said the percentage probably is much higher than ma'am was said, that many percentage of the drugs are still being used off-label for the benefit of mankind, especially the pediatric age groups.
Unfortunately, the companies are not interested in this.
I'll take extra minute. I would like to share my views and pay my respects to my dear friend Kathleen. Kathleen is introduced. We have been using off-label applications of ketamine. In 71, when Thomas gave us ketamine for only IM and IV use for induction of anesthesia, over a period of time, slowly we started using it as a sub-anesthetic dose, 0.2, 0.3 per kg, okay? And then outside OT for sedation. I'm grateful that I've saved many children for intractable touch pills when everything failed with the blockers. A desperate scenarios, amazing for the cardiologist. But what have we done? Literally and intractable. How can I forget intractable status asthmatic age group? The last indication, all the including phosphodiesterase inhibitors were not at all working. Now we are coming across the mood depressing and mood elevators and mood changing applications of ketamine, and FDA had to approve esketamine and the RNI. So esketamine, which is intranasal, has been finally approved of late by FDA. So there is another side of this coin which we have to accept, and if it is being done in the best interest of the patient. Please remember that off-label use, if it is proved, is liable and punishable, and law does not permit in India. And there has been amendment, but make sure that it is not causing any harm to the patient. Make sure that you are within the legal frameworks and I think we can find so many examples of off-label applications of it. Thank you so much.
All right.
Thank you so much, ma'am.
Dr. Sundaram, would you
Madam, again, as a legal person, we will say no.
Exactly.
Because the Sadhana madam and chairperson madam has clearly explained. But it is very clear, when it is off-label, legally it should not be used. Then our people will argue, it will give post-operative pain relief, it will give nice sedation. No scientific arguments. It is not allowed. These are all the things we have to be very clear and careful. Off-label drug usage is not allowed legally. And once you say off-label, immediately the court will give the verdict. It will not even ask for expert opinion. Immediately it will be done.
Dr. Naurange, sir, would you like to comment on it?
I think I totally agree with the discussions going on, but I would draw attention to one particular judgment, which is quite celebrated judgment from Kerala High Court initially and then Supreme Court, in which the off-label use of sildenafil for pulmonary hypertension was initially allowed, and that was an absolutely off-label experimental drug. So though it does not follow this, I mean, generally whatever has been mentioned is correct, but once in a while, such a life-threatening situation can be allowed by the courts. So it depends on whether it is that critical.
Sir, and proper documentation, I think, is the key. that all other, treatment has failed or things like that, and how or why you're using that drug.
Madam, again, as a defender, madam, as a defender, in case if we have used, we can say, as Sarah has mentioned, if it is a pulmonary hypertension, we can defend ourselves that when the Damocles sword is hanging over our head, we have to select a way. But it is not applicable for this post-operative pain relief and all.
No.
Mostly we are using off-label drugs only in the central neuroaxis blockade, only in the central neuroaxis blockade, or this dexmedetomidine or sodium bicarbonate in the regional nerve blocks. So nowhere our usage of additives, mainly we are using only additives. It will not come in life-saving measures. But something has happened, you try to defend. That you have selected a choice between devil and the deep sea. This is again to console the people.
Fortunately, in 9th edition of Miller, all these additives, they are mentioned. So this is the safety for us. And as Dr. Naurange said, that it is only for the rare or the orphan diseases.
Yes,
that off-label drugs use are
we tried.
For example, I am just asking, as Dr. Sundaram said, post-operative pain relief is not an emergency situation. Suppose an anesthesiologist has got an experience, such and such addition is useful. Can we take an informed consent from the patient that this drug has been used by us and it is not accepted by FDA? Is it allowed or it is not?
Dr. Naurange, sir?
No, I think it is not allowed in our country.
Not
legally not allowed.
Unless you have clinical trials. I mean, you have to then put up a clinical trial. So, all right. So we're going to close this topic right here. And next, you will have, okay, tell me.
Sadhna Kulkarni, madam, can you explain, can we use certain drugs, pharma company advice for the suppose for intravenous use? The same drug, can we use intranasally or other routes or intrathecally? Or
if it is mentioned in the label, then only, otherwise not.
No.
Okay.
So the one small thing I would like to ask is that before we used to, for theses, for students, we used to keep on giving things. And then suddenly after I did some research on this, I realized that we cannot just give it for any kind of a thesis because we don't have the background of clinical trial. So it has to come like a clinical trial if you're trying something new.
Leave aside changing the rule. Even if we are using an age-old drug which has been used systematically, I have given the topic in a dissertation when steroids were being used as antiemetics, and the expert asked me, have you taken DCJ approval?
Yes. So please be careful. This is just to increase your awareness. There's so many teachers here and everything. So just thought I would, kind of just bring this up right now. All right. Okay. Do we have time? I mean, we have one more full thing to answer, to go.
Just one question to Sundaram sir.
Sundaram sir, yeah.
Sir, you are saying that we need to follow up the patient post-operatively. Do you have any specific duration? Will it be 24 hours, 48 hours?
Yes, that's what. Sir, I will tell this. Sir, this is a very gray area. See, it is not ours, sir. It is, if it is related to anesthesia, then it continues. Like if suppose some complication has occurred during the perioperative period, it will continue. So it is not the time. What I said, whether legally or not, morally, we have to take care of the patient because we know what is happening and we know what drug we have given. Because some people will give atropine and ephedrine in the perioperative period. Post-operative period, there will be a high BP. If a physician is seeing that, he may not interpret that because his training is different. We know what we have done. That is the reason I am saying it is a moral responsibility. Legally also, we are responsible whether we hand it over or not.
All right. Let us go ahead because, madam, please, questions will be discussed later.
Yeah, because, we are short of time. This is really to just increase our awareness. All right, so we are going on to Dr. Naurange is going to lead us into a very important topic, which is MRI and patient safety, and what are the lessons for the anesthesiologist, because he has just recently handled a few cases in Pune with very poor outcome. Naurange sir, please.
Yeah. So can I have the first slide, please?
Yes.
So thank you very much at the outset, all the organizers, Professor Kalpana Kelkar Madam, Koon Madam, and Pratibha, and also very nice to listen to Dr. Sundaram and Dr. Kulkarni. I think increasingly anesthetist is required to give sedation or even short anesthesia, relaxation for very many procedures in diagnostic centers which may not be attached to or standalone diagnostic centers away from the hospitals. But then there are many situations, in particular neurosurgery, where they are required in the OTs also. And the problems are really inherent. The procedures need sedation, anesthesia, short or long duration anesthesia, muscle relaxants, regional anesthesia, and sometimes in the odd positions of the patients. There is nothing like short, small dose or minor procedure. That I always hate these words, short procedure, minor procedure. It is the maximum accidents which occur in the minor that you are not prepared. So there is nothing like those things. MRI utilizes the anesthetist services maximally, but sometimes you require in CT, ultrasonography also. And basically we have to understand that many situations in an emergency, MRIs are required for basically very sick patients. So these are all inherent risks in this. Another problem in our country is that MR compatible machinery, ventilation, monitoring equipment, resuscitated equipment is so prohibitively expensive that I don't think this is rather available even in the major cities at many centers in a city like Pune, Bombay, etc. So practically non-existent. And inherent, so you have to take out the patient in case there is a mishap. And inherent problem is another thing is long acquisition time. The patient has to wait for a longer time. Then for you, it is an unfamiliar situation and a peculiar environment. I think the basic legal principle on this, that as an anesthesiologist, we cannot absolve ourselves from saying that these things were not made available to me. I was new to this particular situation because of this very important principle that has been laid down long before by National Commission and of course by Supreme Court in Rashmi Fadnavis and Mumbai Grahak Panchayat case, and also in Martin D'Souza, that though he might not, that anesthesiologist might not have been directly engaged by the patient, usually they are called by the center or by the another consultant. The anesthetist is a separate legal entity, that he is a separate independent consultant, and therefore the liability is completely of his. You cannot absolve that patient did not involve me directly, so there is no privity of contract between the two. So that is the underlying principle. So a lot of responsibility lies on the person administering anesthesia. Can I have the next one, please? So the precautions remain the same. So initially check why this. So these are the things which are mentioned in various books. I won't mention about the references. Why this procedure is required, what is the procedure, who is doing it, where it has been done, how it will be done, and when, the timing of it. So we have to ensure the trained staff monitoring, familiarize yourself with the situation, locate the nearest resuscitative facility, whether there is a crash trolley which is prepared, oxygen, defib. So these are the basic things. So preparedness for the life-threatening situation. American Society says that in addition to all which I already outlined, emphasis on pre-operative assessment and investigations, informed consent, intraoperative care, and post-operative analgesia remain the same. Choose the diagnostic center after verifying it. So what is happening is that most of the seasoned or senior anesthesiologists, they say no to go to diagnostic centers. And it is a young population who are in need of the practice. They fall prey to these situations and they don't have the daring to say that I will not do these things over here unless you provide me these things. So I will come out with a solution also. So choose the diagnostic center. It's easier for me to say than practice it after verifying its authenticity. So we are not going to say that whether it has been licensed by corporation or not, but basically theoretically we have to see that whether the person is having the moral integrity, as what sir was saying. Check all the facilities of monitoring and ventilatory equipment, basic at least. Check the consent yourself. Don't leave it to the nurse and assistant. In case of emergency, we have to see that basically the informed consent is there, and also the basic facilities are there for ventilation. Can I have the next one, please? Then point out, in case you find out the deficiencies, we have to point out the important deficiency, lacuna or upgradation, and request them for the subsequent procedures at least. If after a reasonable period of one request, the things are not improved, you have to request in writing. This I am telling you from various judgments, that you are working in a government setup, you are working in a corporate setup, or you are just working in a very totally individual private practice, but the things are not improving. We have to write a letter. We have to take the acknowledgement of that letter that he has received it. Once that is there, something happens, you are fairly, I'm not saying completely, but fairly protected from your side. Have luxurious, that is 1 to 2 crores minimum professional indemnity insurance. And this is required for every anesthetist, everybody. I'm not saying those who are going to the diagnostic center, it is required, because minimally I had detailed discussions with 2 judges in the Bombay High Court. They said that 1 in 2 crores is nothing these days when it is a life liability. So the compensations are bound to be like that only. And also request the diagnostic center to have their own indemnity and establishment insurance. Always, of course, that is, taking insurance is not a license to create or commit negligence. I'm not saying that way, but that is a tertiary prevention. Always take a few minutes to talk to the patient or relatives and involve the physician who has asked for this particular investigation. So that is very important to do it before procedure, not to involve him in a life-threatening situation when the patient has become comatose or has become a brain death patient. As usual, categorize the patients into ASA risk and optimize him. Can I have the next and probably the last slide? Never leave a critical patient unless you hand over to a competent caregiver. Supposing you are shifting, it is our responsibility to hand over to the responsible person. Do not make any hurry to leave the patient unless he is maintaining his vitals well, either with his own or with the assistant. I think this is partly the answer. Somebody asked how long the anesthetist should be there after the procedure. If table death has occurred, follow the usual procedures what you follow in a table death. Involve the medical legal friend immediately in case of any crisis. So don't hand over the papers unless you have involved a medical legal friend. And my request to the anesthesia, so this is the long-term solution, that they should formulate minimum locally practicable. What happens, madam, is that many times we just borrow, or the government borrows the guidelines from Western countries where I'm right now. They cannot be just followed in each and every nook and corner of our city and our country. So there should be locally practicable facilities at diagnostic centers and methodology of assessment, consent, staffing, equipment, etc., and bring uniformity and keep the individual, that means individual anesthesiologists, from any personal embarrassment by asking that these are the things which are required. Once the association puts down the basic guidelines, it becomes easier for him to insist on these. This will surely help in the litigations. I think the next slide is just many cases, so we need not go into them for want of time.
Okay, sir, I'm just going to ask you this usual question. Somebody calls you from the MRI suite and they say patient is not able to lie down and thoda sa yaun sedation there.
Yeah. So for that also, these basic principles will remain, that see that basic equipment is available and at least one trained assistant is there and a proper consent is taken.
And I personally,
because the risk of depression remains, the central depression remains the same.
I personally feel that it is better to take this person out, do a proper check, and then put it, because they are usually not emergencies, they're usually back pain, they can't sleep.
Yes.
And it is always better for the anesthesiologist to not just go anywhere, look for a vein and just start sedation. You don't know what the patient did. He may be asthmatic, he may be anything.
Madam, legally only one point in sir statement. Number 11. Point number 11, sir, please correction. Prepare the notes. It has been written as prepare the notes. Calling the police, expiry. It is not prepare the notes. It is writing down the notes. It is legally, as we are talking about legally.
No, sir, no, I would explain. Sir, I would explain here.
No.
You have always the legal prerogative to ask for time, because on the spot the police come and they try to grab
That's
all the
what,
records. So there you can buy the time. That is what I'm saying. That prepare the notes means
that prepare is a
before handing over to the police.
not a must.
All right.
Proper notes, preparing the proper notes before handing over.
Okay, I know this is becoming slightly long, and I thank all the speakers for doing such a great job. This whole session was about increasing awareness about these problems, not really solving the age-old problems, but I think in your own area of authority, you can slowly start making the change. And I think then we have served our purpose.
I would just like to add one thing, because I'm sure that many people might be having many questions. We don't have time. So if you can hand over your questions to us, we can get in touch with all the...
Okay, these are telephone numbers. Sorry, you can just take a picture and you can, kind of contact these people on your own. All right, I'm changing the slide. Okay, yes, madam.
Can I just have few words about
this
previous one? Just one line. Before we begin. Regarding the MR, I would like to share the legalities involved and these basic morbidities and mortality related. The patient, the relatives, and the team member, basically related to the hypoxic deaths, apart from the flying object injuries attracted to the magnet. The quenching of the magnet is something, and why the patient died, because of most of the cases which have been reported are hypoxic because of the cooling agent, that ozone and helium, which liquidifies the gases and displaces the entire oxygen. So we have to be responsible. We are responsible in maintaining the environment and maintaining. So that's the most important thing, which has found the legal implication and thank you.
CV presentation. All right, so we're going to go on to our next speaker, Dr. Advocate Rohit Erande. I'm so used to saying doctor. Okay, so now we are just finding his CV somewhere, but I think he can take the dais. He is very much involved with lots of blogs, and he does a lot of awareness work for doctors, and I think for lawyers also. Yes. Okay. So let me call Dr. Rohit Erande. Asked his CV. Oh, he did. Oh, he is there. Okay. All right. So let me just read this. He is LLB, LLM, and he is a member of the Bar Council of Maharashtra and Goa, and greatly accomplished. He has done, see, those 350 medico-legal blogs, okay? So, and he is quite gifted. He has, kind of written some book which was published, and he's invited as a speaker. And once you hear him, you will understand what he is trying to say. So we are now, you must be seeing in the papers that FIRs are being dropped on doctors left, right, and center. And let's hope he is going to just make us a little bit less worried. Thank you.
Good morning, everyone. Thank you, organizers, for giving me an opportunity to share my views. Perhaps I have attended many conferences, but this is the first one for the anesthetists who are regarded as unsung heroes, or I may say they do the thankless job, because the patients are not aware who their anesthetist is, and rather anesthetists are involved also. Many patients are not aware. Just a minute.
Sir, are you all able to hear?
Yes.
Yes.
Okay,
Very
so
well.
yeah, they want to be on. All right, these people also
I
want
know.
to be on. No, they are not there. That's why
I
I
see.
thought maybe it's not.
Yes. So that I was referring to that I would say that I'm before the unsung heroes of any operation or any procedure. Now, see, you may be the unsung hero or you may be doing the thankless job, but when it comes to any legal complications, you are treated as at par. So now, as whatever I'm going to share my views, I already shared my blog with Dr. Kane madam. So you may please circulate with your colleagues. Now, as you all are reading in newspapers in nowadays that FIRs are being lodged, and there's a tremendous increase in filing of cases against the doctors in medical legal cases, medical negligence cases, and the patient has twofold rights: civil litigation, civil case, as well as the criminal litigation. Now, the civil litigation is filed for claiming damages, and the criminal litigation generally comes when if there is any death of a patient, then the police machinery is involved, and then automatically the case is filed. So now I'll be stressing more on the criminal aspect, because see, nobody wishes to go behind the bars, and we try hard to save ourselves from going into the police machinery and going behind the bars. Now, in case of any death, because see, generally FIRs are lodged when there is a death of a patient, if not in other cases of medical negligence. So the first section which is applied by the police, I am pausing here for a moment. Please always have in mind that it is the prerogative of the police authorities to frame the charge which they want. So which section is to be applied? It is the first prerogative of the police. They may apply any section under the IPC. It is their right. Whether that application of section is correct or not, that will be decided further by the court. So if there is a death of a patient, then most of the doctors are feared about section 304. That generally we all are aware that culpable homicide not amounting to murder. So this section is divided into two parts: culpable homicide amounting to murder, म्हणजे आपण ज्याला मराठीत खून केला असं म्हणतो, and culpable homicide not amounting to murder, means the person knows that the person is going to die, but he had no intention of killing him. So in medical legal cases generally fall in part 2, and this section is I would say very important, because it is a non-bailable section. It carries 10 years imprisonment as well as fine, and this is a cognizable offense. So FIR is immediately lodged. And the subsequent section is 304A, part 304A, causing death by rash and negligent act. So that is a bailable offense, and the punishment is only of 2 years. But now, if suppose a patient is dead in OT, and the police machinery gets involved, then which section is to be applied? It a lot depends upon what police is going to play the role. So see, there are many ways, there are many I would say facets of it, and right now I cannot tell how to deal with the police, and see, because ultimately you are answerable to police. Now, going back to the 304 part 2 matter. Now, previously what used to happen is that एखादा पेशंट गेला की पोलीस यायचे आणि डॉक्टरला लिटरली दे यूज टू अरेस्ट, डॉक्टरला उचलायचे, आपण जो मराठीत शब्द वापरतो. सो म्हणजे दिस इज अ मोर डेरोगेटरी वर्ड, बट फॉर देम की आम्ही डॉक्टरला उचलला, मीन्स टू मेक द अरेस्ट ऑफ द डॉक्टर. बट आय वुड से दॅट in the year 2014, Honorable Apex Court in its 5 judges constitutional bench judgment gave a very important verdict that in case of a death, they have made the 5 categories that and the categories are matrimonial dispute, commercial offenses, corruption cases, abnormal delay in filing FIR, and the last one is medical negligence cases. So they have specifically added medical legal cases, medical negligence cases, And what they have held at, it will be unfair and inequitable to prosecute a medical professional only on the basis of allegations in the complaint. And this is what used to happen previously. So after this judgment, now a preliminary inquiry is a must. And unless that inquiry is done by the police authorities, that is, unless they obtain a report from, in case of Pune, say from Sasun Hospital of expert committee, they cannot, arrest the doctors merely because the patient is dead. So this particular, I would say, the important factor was not previously available, because we all are aware of the Jacob Matthews judgment. Which they have defined the what should be the negligence, what the negligence should be the gross, and then only a doctor can be criminally prosecuted. But this authority was applicable only 304A, where the punishment is only for 2 years. But if the police used to apply 30 part 2, where the punishment is of 10 years, then there was no protection, and the doctor had only right directly approach the Honorable High Court for quashing the FIR. But after 2014 judgment, see, you must be aware of the judgment, because suppose unfortunately something happens and police authorities come to you, then see, you are this is your right of fair trial is a fundamental right of every citizen, and therefore I would request that you should know the judgment, you should know your rights, and at that time you can always tell to the police that you cannot arrest me in a routine manner because this is the judgment of Honorable Apex. So 304 part 2 and 304A. So which section is to be applied? It is the prerogative of police. Now, another important aspect which I am going to touch here is removal of wrong charge. As initially I just mentioned, charge means the which section is to be applied. So suppose police applies 304 part 2, that you have committed a murder but not culpable homicide, not, and you are sure that you did your best, the patient died on OT because due to some medical complications which are beyond your control, you can always apply to the concerned court of removal of charge, alteration of charge, or your discharge from the charge. But that will only happen only after the case is registered, not prior to that. So it lot again and again I am emphasizing that it lot depends upon the police authorities, police machinery, because we all are concerned with the currently of the criminal action. Then again, another important aspect which a doctor or any doctor or anesthetist should be aware, that you may be called as an expert witness or a witness in any medical legal cases. So suppose you receive any warrant or any summons from the court, or any notice for that matter from the court or from any lawyer, my first advice would be you should accept that. Many a times it is a human tendency, not in any legal cases, ki apan notice refuse karun takaisi, not claim karaisi. But that is not going to help you, because you won't be able to know what exactly written is there, what are the allegations made against you. Merely because you just say, I don't want, you say no, not claimed or unclaimed, that is, you will be in more trouble if you don't accept it. So you always accept that whatever the summons, notice, it is received, is sent to you. But first of all, see whether it is in your name, because many a times it may happen in court proceeding, the name is wrong, dusra doctor cha aale. In that case, you are right to refuse, because I am not that person. Since you know that it is addressed to you, but you can in that case take the benefit of the technicalities. So now if a warrant is issued, if a witness summons is issued to you, you have to obey it. You cannot say that I am not going to come. Even if you have written anything on the paper that this paper is not going to be used as evidence in court, etc., asa kahi hot nahi. Whether any particular document is admissible in evidence or not, it is decided by the courts and not by anyone else. So you always have to obey the witness summons if it is issued to you. Only thing is that generally the courts do give preference to the witness doctors when they come to the court, and by keeping aside other work, the doctors are given preference in these days, because right from 1987 Paramananda Katra judgment, Supreme Court has held that doctors should be given priority whenever they come as a witness. It might be the case of attesting to the will, or it might be the case of the medical legal cases. In another important aspect is that, see, as we all have seen now that litigation is going on. Many times cases are being filed against the doctors, and anesthetists are also involved. Many a times it happens that the cases are decided on merit, decided in favor of doctors. Then many of my doctor clients ask, sir, what's to be done? Whenever I advise them, you have a right to file a suit for damages for malicious prosecution. I have seen in my last 20 years, not a single doctor is ready to go against the patient. See, merely venting your emotions on social media or on WhatsApp, this is going, this is not done, this is bad, or where is the society is going, it's not going to help. If you want to set an example, if you want to have some deterrence in the society, then you should initiate, at least some of you should initiate at least a notice. I am not saying that you should go and filing and claim 50 lakhs and 1 crore rupees as compensation. That is up to you. But unless you do, unless one of you do, unless your association do it, see, it won't go a message in the society that you can do anything. Because what is happening is now this has aspect of civil litigation, CPA. Now the CPA, as it is called as sword of Damocles hanging over the heads of doctors. See, by merely paying 500 rupees, 5 or 1000 rupees, I can file a suit up to 50 lakhs rupees in Pune District Forum. Previously, it used to happen for the as per new CPA, they increased the pecuniary jurisdiction to 1 crore rupees. Now, recently, I fought a case for doctors. It's a very famous case in Pune where 90 lakhs rupees were claimed against a gynecologist for D&E procedure and the patient collapse. And the anesthetist was also involved in that case. Fortunately for us, the anesthetist was not made a party. I don't know who advised them, but all the allegations were against the anesthetist that it was the overdose of anesthesia. And the patient was saying that मी जेव्हा प्रेग्नंट होते तेव्हा मला अनेस्थेशिया दिला होता, मला काहीच झालं नाही. पण ह्या अनेस्थेशियामध्ये मला माझी बायको गेली, त्यामुळे अनेस्थेशियाची मला ॲलर्जी आली आणि माझ्यापासून लपवून ठेवलं. नाऊ देर आर डिफरंट टाइप्स ऑफ anesthesias and etc. See, all these things should be made aware to the patient. And what Dr. Naurange sir rightly said, you should have a dialogue with the patient. See, ultimately, all the disputes, all the differences start with the ego classes. That doctor bollas nahi mayashi. He had no time. He sent his junior. This won't help you. You have to spare 5. You may examine 2 or 3 patients less, but whatever the patients you are going to examine, at least give proper time to them. And because these 2 minutes are going to save you, because you might be hearing that nowadays courts have awarded few crores of rupees as compensation. And see, ultimately, if you don't have the indemnity policy, you have to pay from your own pockets. If you want to challenge that order, now as per new amendment, you have to first deposit 50% of the amount compensation which is allowed. So in our case, if court would have allowed complaint of 90 lakhs rupees, my client would have required to pay 45 lakhs rupees first, then only we would have got the stay. Fortunately, it was decided in our favor. We had a very good case, but it cannot happen every time. And another last point, I'm just concluding, documentation has no alternative. Communication of documentation of communication, both are very important. So documentation has no alternative. I have personally seen in one of my close relatives' surgery, the sister took the anesthetic consent. I was knowing all the doctors, the surgeon. I told him, boss, look what kind of consent is being taken. You are aware that if something goes wrong, I'm not going to file a case against you. But if this is happening with reality with other patients, then later on do not complain that the informed consent was taken. The word informed is important. So have time, spare time with the patient, and proper documentation again, because no documentation is no proof. Poor documentation is poor proof. Ultimately, in courts, the papers speak, and not what your moral or your emotions have no value in the book. So thank you very much for calling me here, and I hope if you have any question you may ask. And I have shared my blog with madam, so you can just go through it because it's a big blog. Yes, sir. Sorry, I'm not able to see you because of the light.
Anyone can claim any amount, like is there any कुठलाही पेशंट कुठलीही अमाउंट क्लेम करू शकतो का अंडर CPS सिव्हिल लॉ असं काही आहे का की सपोज सम पेशंट 1 करोड अमाउंट क्लेम केली lawsuit साठी तर he or she has to deposit some 20 lakh rupees or 50 lakh rupees something like that.
No, this is not असं काही नाहीये. बेसिकली कोर्टात जाण्यापासून तुम्ही कोणाला रोखू शकत नाही. मला जायचं असेल उद्या तुमच्या विरुद्ध कोर्टात तर आय हॅव दॅट राईट आणि मी किती पैसे क्लेम करायचे तो सुद्धा माझा राईट आहे. हे जर सिव्हिल कोर्टात असेल तर आय एम रिक्वायर्ड टू पे द कोर्ट फी दॅट इज अप टू मॅक्झिमम अप टू 3 lakhs of rupees. But as CPA is regarded as a social legislation, so they have not applied the principle of court fees. So that is where the undue advantage of the CPA is being taken by the patient.
So theoretically anybody can claim any amount.
Any amount. See, now that is depending upon the pecuniary jurisdiction. Now previously only it was 10 lakhs rupees. Now after 2019 new CPA they made it. I'm talking about district forum. They made it to 1 crore rupees. But again, last say 6 or 8 months back, they again reduced the pecuniary jurisdiction to 50 lakhs of rupees. So up to 50 lakhs of rupees, any claim can be filed in Pune district forum. Above that, state forum, and above 2 crores directly to national.
Advocate sir, this is Dr. Meenakshi Sundaram from Tamil Nadu. I am asking by Zoom platform, sir.
Yeah. Sorry, sir. I didn't.
Sir, I am asking by Zoom platform. As you have rightly pointed out, it is the prerogative of the policeman to book the section. Same way, what I'm asking, we have so many judgments, doctor should not be arrested, everything is there, we are having it in hand. But again, the police people are arresting, knowing or without knowing, we cannot discuss it in the open forum. They are arresting or they are taking us to the police station, they are harassing. What I'm asking, see, once this harassment is done, later we will come out because of the court judgment. As you have pointed out, can we file a case against the concerned sub-inspector of police who is the IO that he has wrongly applied the sections, or we have to file the case against the government? Because every time it happens, we have met the SP, everyone, but they will say, sir, beat the about there, please adjust, it is only a formality. But once it is done, what is the section we can book the police under?
The problem is, I think this is the demand or dream of all the doctors that we want to sue the police. But the police or any government authorities are protected by the section itself that any act done in good faith by them, so they are protected and no action can lie against them. So this is, but you can certainly file a case, but again onus will be upon you to prove that they didn't act in good faith, they act with a malafide intention. So everything boils down to the proving of the case. In that case, you can sue the government, certainly government as an entity, but as an individual police inspector, it will be very difficult to file a case. Rather, I would say it will be very difficult to prove it that he didn't act in good faith.
No, sir. The only point is, once the doctor is arrested, it is evident a doctor cannot be arrested at the drop of a hat. But once the doctor is arrested, I am asking whether it is possible. We need not prove, it is already there. The Supreme Court has given the verdict, the doctor should not be arrested at the drop of the hat. But they are doing that.
Sir, one case I can just quote that on the insistence of IMA Pune, the concerned party put a case against Commissioner of Pune in that Dr. Tamane's case. And the Bombay High Court has given very strong observations against the police department. So we can do that, but it's very difficult. Practically, it is difficult. Once in a while, we have done it. And it has acted very well in Pune.
Yes, it is. I think perhaps it is the only case.
Only case, probably. So the doctor has shown the courage, though we go on in, advising the same to everybody, but no, hardly anybody does it.
Yes, no one.
But we can take them to task.
My request is whether the advocate Rohit sir can help in that.
I am certainly there to help. I am there. I go to court every day.
I think there should be a clause against doctors also with acts done in good faith and not punishable.
I wish.
Yes. Actually, that may be the defense. Section 83, 84. I'm open to correction in IPC. If you've done something in good faith, then you are saved. And this section is applied generally when there is if there is a death of a patient. That generally it is said na ki tu muddaun marla patient.
Section 54,
Sir,
sir.
thank you.
Good say.
Excuse me, we can. No, we are really running short of time.
छोटंसं विचारायचं की आफ्टर टेबल 10 किती वर्षांपर्यंत पेशंटचे रिलेटिव्ह तुमच्या विरुद्ध
CPA मध्ये असेल तर 2 वर्षाचं लिमिटेशन. 2 years from the date of cause of action. That is in this case from the date of death.
She's asking about
Criminal or civil you said. Criminal has no limitation.
No limit. Now you said now that you are supposed to pay some amount. But एखाद्याची आता पुणे इथली practice, I am practicing in Pune. So are they can file the case in Pune, I mean district or state?
Now, just last moment, the CPA, the very important amendment which CPA has got, the madam has asked one question, where a patient can file a case. Now, previously, where the cause of action or where the has taken place or where a doctor carries its business, previously in that territorial jurisdiction court only the case could have been filed. But now, a patient from Delhi comes to Pune, takes any treatment and something goes wrong. And if he goes back to Delhi and again then to Meerut, to his native place, he can file case either in Delhi, in Meerut or in Pune.
Thank you, this topic
is never
ending. I'm sure you have many questions, but please ask them in person. Thank you very much for
Thank you
very much. Thank you.
My first slide.
माझी CV.
My CV. You want his CV? सरांची CV तिकडे आहे म्हणजे ह्या याच्यावर नाही.
I can just tell 9823370028 if anyone wants.
I'll put it on the. Thank you so much. Madam, vote of time. Who's giving? Okay. All right. I think we are concluding this session. Thank you very much for your active interaction. Thank you, madam. Thank you. I thank all my speakers for their deliberation. And I think, as usual, the medical legal session has gone on longer than we expected. But thank you, Dr. Sundaram. Thank you, madam, for being there. And thank you, Dr. Kerkar, madam. Thank you, Dr. Kohn. And thank you, Dr. Advocate Aaron. Anyway, thank you very much. Well appreciated. Thank you.
Log out. Sujit sir, log out.
Log out. Log out.
To log out. To log out, thank you so much. Thank you so much, sir. Now I request our chairpersons to kindly felicitate Advocate Rohit Aranda sir.
Sorry, end करना है.